In spite of the rains, a very warm welcome and thank you for being here. Let's give ourselves a big hand on ourselves on behalf of all of us that there is a lot of hope still left in spite of we the people showing a little bit of shaking up this government by your very active support during the elections all over the country. There will be always struggles, particularly in the area of development, in the area of human rights. That's why we are meeting here very specifically to talk about the new criminal laws for which we have very eminent and knowledgeable key resource persons whose introductions we will share later on, who will give us insights into what is at stake for us and what we could do and you could do together to at least change what's really happening. Very interestingly, while they have said that by July 1st they're going to implement this new criminal laws, but if you'll notice, very suddenly, in some parts of the country, some of the police officials talking about a very good criminal laws. And one of them has said that this new criminal laws will have very efficient and speedy justice. All of us know Swiggy delivers pizza better than when you call the police for assistance. And very noticeably, the same police, when citizens need help, they never announce the procedures or processes as much as in the last 2-3 days we have observed all sorts of videos being circulated talking about the efficiency of these new criminal laws, which have still not been implemented from the point of view of actual action. So there's cause for worry. It should ring bells in your ears. Why suddenly the police, some of them who have lost their spine and make do with the political masters, rather than actually enforce the rule of law? Many of them don't believe in enforcing the rule of law, are talking about speedy and quick justice under the new criminal laws. So we want you to listen with an open mind to the insights that three eminent people are going to share with us. And I'd like to invite them on the days, beginning with Advocate Vrinda Grover. Vrinda has flown from Delhi to be with us to share her insights. Can we give her a big hand, please? I'll also call upon Advocate Vijay Hiremath. That's right. More of them, we will share it with you when they start speaking. And our very own Teesta Setalvad. We would like to begin in terms of the context with Teesta sharing with us. I'd like to briefly introduce to you Teesta. A senior journalist and a human rights defender, best known for her decade-long campaigns against communal hate and violence. She is also known for her strategic legal interventions to defend the rights of the oppressed, the wronged, and the marginalized. She is currently Secretary of the Citizens for Justice and Peace and also Vice President of the All India Union for Forest Working Peoples. Apart from being President of the Gauri Memorial Trust, Setalvad not only co-founded Communalism Combat, a magazine that delved in the incidents of communal violence and examined their underlying causes, but also went on to co-found Sabrang India, an online publication that aims to foster harmony amidst diversity and bring to light injustices and human rights violations. So, can I request Teesta to set the context of today's evening meeting?
Thank you, Dolphy. Thank you, Bombay Catholic Sabha. Thank you, St. Michael's Church, for this wonderful venue. Friends, reform or repression, that's the kind of question we've tried to pose about the new criminal laws that are coming into force on Monday, July 1st. I mean, there is no two ways about it. July, they've been passed in Parliament and they've been notified to be coming to force on Monday. Tongue twister names, very difficult to say, but we'll have to begin to say them. Bharatiya Nagrik Suraksha Sanhita, BNSS, Code of Criminal Procedure. Bharatiya Nyaya Sanhita, BNS, replaces the Indian Penal Code. And the Bharatiya Sakshya Adhiniyam Act, 2023, replaces the Indian Evidence Act. See, the first thing we need to understand about these laws is because any law in a democracy needs to go through Parliament. And if it's going through Parliament, which is supposed to be a voice of the people, as we at least believe to know it as students of the law and students of civics and the Constitution, it must reflect differing, diverse voices of the people, any new such a radical laws that are passed. And if you're completely changing the edifice of criminal law, as these laws are doing, surely proper, detailed, elaborate consultations were necessary before they were passed. This did not happen. After they were tabled in the last monsoon session in August 2023, they were rushed through in December of 2023 and without any debate, any dialogue, at a time at which 146 members of parliament were actually suspended. So we need to understand the unseemly haste with which this regime has wanted to pass these laws, and then we probably understand why this unseemly haste when we actually see the very, very problematic, even draconian provisions. One of the aspects we need to understand when we look at these laws is, and put them under the test of, are they a decolonized law? Do they move more towards making us a citizen out of us from being a subject or a supplicant of the state? That's what decolonization means. And I like to say, which I've been saying for the last 10 years actually, that it's not as if up to 2014, we were a perfectly representative, diverse democracy. We were a democracy in the making, so to speak. There were struggles, there were pushes, there were pushbacks, and there were spaces that were fought for and won by struggles of the people, civic society, human rights struggles, lawyers, and the rest, including within the field of the law. Have the CrPC, IPC, and Indian Evidence Act never been amended before? That itself is a joke, because I mean, any student of human rights or the law knows that there have been several amendments. The CrPC itself is a 1973 code now, and after that was amended several times, very often because of pressing jurisprudence in the constitutional courts. And please understand this, because that's the first point I want to make, is that when the courts rule down certain provisions of a law that has existed for 150 years, and then Parliament is required to make an amendment, it means that you're trying to constitutionalize an otherwise problematic law. This happened with the Basu case, it has happened with detention, the rights of arrestees, it's happened with the Agnesh Kumar judgment on the question of bail. It has even happened in 2009 on victimology, which is the rights of victims to be present and appear during a criminal trial after the famed Best Bakery case of 2004, which delivered a historic judgment by the Supreme Court, acknowledging that victimology was a serious issue which was unaddressed until then by the CrPC. So there have been several amendments in the law moving it towards the sphere of more accountability, transparency, and possibly acknowledgement of all of us, you and me, as citizens rather than subject. A very, very crucial issue with which Ms. Vrinda Grover was involved were the 2013 amendments. And we need to remember that, because, how the infamous, ghastly, brute assault on Nirbhaya, the Nirbhaya case of 2012, resulted in drastic changes in our jurisprudence, and not jurisprudence first, actually the law, with the Justice Verma amendments as they are known in 2013, which talked about the sexual assault and the violence against women. So, first of all, let's be very clear. It's not as if the CrPC, IPC, and Evidence Act have not been amended before. Secondly, let's also remember that apart from the unseemly haste, we must understand that the Wire had reported, in fact, in August last year, that there was a committee set up. There was a committee set up in 2020, if I'm not mistaken, and this committee functioned in great secrecy. And right to information activists, I think including Venkatesh Nayak and others, kept trying to get more information from the MHA and others about this committee, which information was refused. And who were the members of this committee? The members of this committee were the Vice Chancellor of the Delhi University, I believe his name is Professor Srinivas Rao, the Registrar, and the member and convener. And those who were unofficially involved, the Wire quoted, were none less than the Solicitor General Tushar Mehta and the ASG S.V. Raju. So we have to understand the context in which this kind of law has been framed and brought before us, because the manner in which it has been pushed through, I think, forces us or compels us to remember the context and chronology, as the Home Minister is fond of saying. I would argue that by, in fact, handing over arbitrary powers to the police and the administration, powers that were with great difficulty, read down and handed over the years, what this government has done, and it's an autocratic government, let's not make a mistake about it. It's an autocratic government that actually believes in the conversion of the Indian state into a theocratic autocracy. What it has done is deconstitutionalize our laws. I have a much more battered copy of the Constitution than Mr. Rahul Gandhi carries, but I do carry around with me all the time. And if you read these new laws and these amendments, in consonance with Article 14, Article 19, and Article 21 of the Constitution, and even Article 22, which is to do with preventive detention, you realize that these new laws, which are supposed to be decolonized, in fact violate seminally all these constitutional provisions. So quickly, I will just go through some of that by saying that, therefore, the intent behind the laws is to actually make us more of supplicants before a autocratic, theocratic state, so that any dissenting voice that questions, even though we may have rights under a constitution which these laws do not recognize, to dissent, to protest, to speak, will actually be overruled by these draconian criminal laws. So you have, in fact, a very, very contrary state of affairs. I would argue also that these laws are not just have they to go in for a constitutional test, but in fact these laws have mocked the Indian Constitution. They are a mockery of the Indian Constitution, and they mock the sovereignty granted by the preamble to the Constitution, and they mock the constitutional provisions contained in Chapter 3, which is the fundamental rights of the Indian Constitution. And that makes them very, very dangerous. We have here Vijay and Vrinda, who are really experts on criminal law, and also are amazing human rights advocates of the kind that we do not see very often, in the way they stretch themselves out in the field that they're involved in. So I will not go into the technical definitions of these sections, but I will flag how Article 14 is seriously impaired and affected and violated by the reintroduction of what is known as Sedition Plus, as Professor Mohan Gopal put it in the Delhi exposition where Vrinda was also present. The unlawful activity section, the terrorism section, and in the Supreme Court in May 2022, I think, on affidavit, the Union government committed itself to saying, in the words of the Prime Minister then, who's also the Prime Minister now, much to our misfortune, that they will actually get rid of the provision of sedition, but it has been very, very not so cleverly reintroduced in Section 152 with actually very far-reaching definitions of vague terminology of subversive activities, which can be interpreted in a very arbitrary manner, leading to unequal treatment under the law, and booking of legitimate democratic acts as acts of terrorism. There's also a provision in the new laws, BNS, that criminalizes resisting, refusing, ignoring, or disregarding any direction by a police officer. Section 172. If we come to Article 19 of the Constitution, which is freedom of the speech, expression, the freedom to mobilize, peacefully assemble, the freedom to associate and form unions, all of these, of course, they have been also diluted before by amendments of the Constitution, unfortunately, but they are seriously, seriously impacted by the new laws. Apart from Section 152, you have the sections on crime of organized crimes and petty organized crimes, which have now brought in extremely draconian provisions, which I'm sure our esteemed experts will speak about. Section 226 of the BNS actually talks about and this I think is very important for some of us who go on hunger fast, because we use that as a powerful form of protest, and I just imagine what would happen to poor Gandhiji if he was protesting now because of the number of hunger fasts he undertook. That Article 226 talks about the act of fasting as an expression of dissent, which we know it as an expression of dissent, has been categorized as, quote unquote, an attempt to commit suicide with the intent to compel or restrain any public servant from discharging his official duties. So when we protest something under an hunger fast, we can actually be penalized for that under this new law. Article 21, Vrinda has spoken about it brilliantly a couple of times in Delhi, so I would much prefer that we hear it from here. But I think just the question of what the right to life has been expanded by jurisprudence over the years, whether it's the Puttaswamy judgment, the right to legal aid, so many issues have been brought in, the right of refugees, the right of displaced persons, so many issues have come under Article 21, and much of these seem to be diluted under this new law. There is also a provision which I think technically there is some debate going on even among human rights experts, but on the question of arbitrary extension of police custody from 15 days to a much longer period, the whole question about whether you can have bail provisions are so easily got, whether anticipatory bail can be easily got. These are some of the things that I would really request our experts to delve into, because they actually concern each one of us who've been at odds with an increasingly weaponized administration. Finally, and I think this also concerns many of us who are into feminist legal practice, that the manner in which this BNS, I mean, if you remember, the Delhi High Court had actually read down Article 377. And then, of course, it went up to the Supreme Court, and then after one huge glitch, the Supreme Court again upheld the reading down of Article 377, which is decriminalizing same-sex association. However, the non-consensual acts against men which amounted to unaccounted sex under Section 377 remain criminalized under IPC, through which men were given protection. Notably, the BNS law does not have a mirroring provision. Bestiality is also a defining feature of the offense under Section 377, and this finds no place in the law. Adultery, in one form or the other, has been reintroduced, and the new definition is sexual intercourse or whenever a partner is enticed away from a marital relationship that has been defined as adultery. Death penalty has been retained in many cases. So in conclusion, I would just sum up 8 or 10 ways in which these, in simple layperson's language, what the chilling features of the new criminal code is. The criminalization of legitimate, lawful, non-violent, democratic speech or actions, which could be defined as terrorism. The broadening of the offense of sedition in a new and more vicious avatar, what could be called sedition plus. The expansion of the potential for selective persecution, targeted politically motivated prosecution, and ideological political opponents. The criminalization of a common mode of political protest against government through fasting. Encouraging the use of force against any assembly of persons, again against Article 19, 1 and 2 of the Constitution. exponentially enhancing the police raj by criminalizing, resisting, refusing, ignoring to conform any direction given by a police officer. Handcuffing has been reintroduced, which is hugely problematic. It took a huge battle across decades. I think Justice Krishna was the first one to have this powerful judgment against it. And yet we can see police officers itching to use handcuffs all the time. And that is why what Dolphy referred to, police officers from even cities like Mangalore really welcoming the new laws, because I think it's really dream laws as far as they're concerned. Making the recording of FIR discretionary. Now, everybody knows who's working in the area of human rights, how difficult it is to register legitimate FIRs. And now this has been made even more, this has been legitimized essentially. Compelling all persons, even those not accused of any crime, to provide biometrics. Now, this is again a very problematic. Anybody can be asked to provide biometrics, which means we are increasing the possibility of surveillance and shielding. And this I say with responsibility, actually shielding Sangh Parivar activists, because while 151A, B, C have been retained, and those are the only provisions, Vrinda, we use against hate speech, because in the absence of everything else. But 153AA, which was introduced but not notified, I believe, which actually was a movement towards penalizing crowds or mobs or processions that are armed, that has been dropped in the new laws. So we know as of today which are the processions and mobs even that go into armed processions in the name of a politicized religion or faith. So it's likely that they will get, and they enjoy complete immunity under this law. There's nothing to penalize them. So the broader definition of offenses, the vague definition of offenses, and the handing back of certain hard fought for provisions through human rights movements, jurisprudence, legal movements, etc., have been reintroduced in the name of decolonization. This is not decolonization. This is the laws that an aspiring Hindu Rashtra would like to bring for its subjects to make them supplicant ideologically and not in fact speak on the basis of the constitution. They actually militate against participative democracy and the democratic fabric of this nation. More than anything else, and I repeat this because I think this has to be part of our campaign, they are a mockery of the Indian Constitution. They are a mockery of the fundamental rights section of the Indian Constitution, because we've not yet managed to completely constitutionalize all our criminal laws. And in the middle of that process now, you have a whole set of new laws which actually take us far, far backwards. I'll stop here because far more eminent experts will be able to put it even better. But I really want to thank Vrinda and Vijay for being with us today. And for all of you in the audience, because please let's really make this, for whatever it's worth, into an ongoing campaign. It cannot be just one meeting. It cannot be just one set of letter petitions. We just have to keep on protesting in the hope that if nothing else, the courts will intervene. Thank you very, very much.
Thank you, Teesta. You are one of our bravest voices. And I know for sure on the other side of the fence are also equally brave voices who have a platform to work together to raise the pitch. Vrinda Grover is a lawyer, researcher, and human rights activist. Her commitment and passion towards human rights has been defined as unparalleled by many. She has contributed to the drafting of laws to protect women and children from domestic violence and sexual violence, besides advocating for laws prohibiting torture and legislation for protection against communal and targeted violence. In 2023, she has been appointed by the Human Rights Council President to serve as the member of the Ukraine Commission of Inquiry. May we listen to you, Advocate Grover.
Good evening, everyone, and thank you to the organizers, to Teesta and Dolphy. Thank you very much. I'm going to plunge right in because we do have these laws coming into force from Monday, 1st of July. Teesta has already set the context, the political context, the philosophical context, and the constitutional context. I will add just a couple of strands to that. And when I speak, I would like us to keep those aspects at the back of our mind to understand where is this criticism coming from? The government has stated that this is part of a decolonizing process project. And therefore, as Teesta mentioned, the journey of independence is from the journey from being a subject to a citizen, the citizen which is at the heart of the Indian Constitution, particularly Chapter 3, the objective and purpose of which is to restrain, curb, minimize the power of the state, make the state accountable, all its instrumentalities and agents accountable, and to affirm and guarantee and respect the rights and freedoms that we as citizens and persons have, which inhere in us. What we see happening in this process when we read the BNS, the BNSS, and the Bharatiya Sakshya Sanhita, BSS, is that the journey is now regressing, and we are being mutated from a citizen to a suspect and a mute spectator. And I would illustrate that through some of the provisions that I will speak about. The other aspect that Teesta did mention was, yes, there have been many amendments, but why and how? The amendments have come from people's lived experience, they have come from movements, they have come from campaigns. They have not come from a committee, and that committee actually comprised of 3 men. Professor K.D. Rao, who's presently the Vice Chancellor of Nalsar, Professor Bajpai, who is now the Vice Chancellor of National Law University, Delhi, and Mahesh Jethmalani, the senior advocate from your city, who is affiliated to the Bharatiya Janata Party. The representative character of that committee is before you. Nonetheless, when those questionnaires were posted online in 2020, in the middle of lockdown, because there was some urgency to amend the laws before Amrit Kal dawned upon us, many of us, including Vijay, made a Herculean effort to actually write copious answers to those questions. The process of consultation doesn't mean that I respond and then we don't know what happens to that. The process of consultation is a process of engagement, which we have seen is totally absent both inside and outside the parliament. And it is not surprising, therefore, that we have what we have, where there is also absolute legislative negligence in certain parts, because what is written is incoherent. So it's not even, if there is a criticism or based on constitutional threshold, but there is also completely poor drafting where nobody cares what they are writing. The entire criminal legal system, and I think we need to stop calling it the criminal justice system. Words have lost their meaning, and therefore calling it Nyaya Sanhita does not imbue it with any elements of justice. The criminal legal system operates on an assumption that long ago, actually prior to 2014, has been repeatedly hollowed out, and now there is nothing left of it. The assumption that the state, through the police, through the prosecution, will act in good faith. That is not the state of affairs, and there is enough evidence documented, both in records created by citizens, which are as legitimate, as well as in the judicial archive, to show that the state is acting in bad faith. And if there is a serious engagement with what is truly decolonization of the law, then that process would make the state accountable and would actually challenge whether the good faith is to be parked with the citizens rather than with the state. I will now mention some of the provisions to which I would like to draw your attention. Some have been already mentioned in passing, both in what has been written and what are the legal silences, which this was as good an opportunity as any to actually introduce into the criminal codes. Reference was made to sedition, which, as we know, has been stayed as an offense by the Supreme Court. All trials, all prosecutions, etc., of the offense of sedition, section 124A, have been stayed. And we were told, and I will take a little bit of time because I find this absolutely fascinating, the affidavit, the counter that was filed by the Union of India, which actually the then Chief Justice of India reproduced in the order, which said, the Honorable, and because it was in the name of the Prime Minister of India, it is recorded so in the order. The Honorable Prime Minister of India has been cognizant of various views expressed on the subject and has also periodically in various forums expressed his clear and unequivocal views in favor of protection of civil liberties, respect for human rights, and giving meaning to the constitutionally cherished freedoms by the people of the country. He has repeatedly said that one of India's strengths is the diverse thought streams that beautifully flourish in our country. This is the Union's affidavit reproduced. The Chief Justice is not saying that he said it. This is the government saying that the Prime Minister said it. Clearly, there are some secret parleys which you and me may not have heard, but that's all right. They can have their private meetings. The Honorable PM believes that at a time when our nation is marking Azadi Ka Amrit Mahotsav, 75 years since independence, we need to, as a nation, work even harder to shed colonial baggage that has passed its utility, which includes outdated laws and practices, etc. And it says, specifically, in this spirit, the government has scrapped laws, etc., which are unnecessary and causing hindrance, have to be decriminalized. The government of India, being fully cognizant of various views expressed on the subject of sedition, and also having considered the concern of civil liberties and human rights, while committed to maintain and protect the sovereignty and integrity of this great nation, has decided to re-examine and reconsider the provision of 124, etc. What comes in place of that? As was mentioned here, what has come? Yes, the word sedition is missing, but the offense has actually been enlarged. It is now so overbroad and vague. Already we had seen, and the reason why the Supreme Court agreed to intervene, and I represented two women editors, Anuradha Bhasin of Kashmir Times and Patricia Mukim of Shillong Times, in that matter, looking at how the offense of sedition silences freedom of press, particularly in these areas. Now we have section 152 of the BNS, the Bharatiya Nyaya Sanhita, which does not use the word sedition, but says endangering sovereignty, unity, and integrity of India, and actually has expanded the offense. And I'll read out one phrase because at least, and there are no definitions in law, in criminal law. What is the principle of drafting that is followed across the globe? The principle is certainty and the principle is precision, because without that, the interpretation of an offense by a court would be both difficult for a judge and would be highly subjective and arbitrary. These two principles are totally absent and missing from the kind of drafting that we are now seeing in the new criminal codes. And the example of that would be, apart from many other words that have been added without any definitions, if talks that are the presentations being made here encourages feelings of separatist activities, how do I understand whether somebody speaking on a controversial subject, whether it would encourage a feeling? The police officer is now going to be able to, and we have senior police officers sitting here, the police officer will be able to ascertain not an activity, an action. Criminal law has two elements, mens rea and actus reus. Intention and your act in order to formulate an offense. But a feeling that you may have can actually now come within what was described as sedition 2.0, and there are no definitions for what is separatist activity, what is subversive activity, or indulges in or commits. I've practiced law for 30 years. What is indulge? I understand commit. I can commit an offense. I can attempt to commit an offense. I can make preparation. I can conspire to commit an offense. But what is indulge? We don't know what these words mean. Who will determine? Basically, who is going to determine from 1st of July is the man or the woman sitting at the police station who is going to start using these provisions when complaints, FIRs, etc. are lodged. So this is how the Prime Minister's assurance, not just to people, but actually to the Supreme Court of India, has played itself out in drafting of the sedition provision. And as was mentioned again, so what happens to Article 19 and what happens to all our freedoms? And that is the touchstone and the test that every single section in all the three codes will have to meet, without which, when the challenge is made, when the challenge is heard and decided, they will have to be struck down. Then you have the liberty to free speech, expression, assembly, etc., all stand jeopardized. The other aspect here, and this is unparalleled. So yes, for novelty, full marks. Chapter 4 of the Unlawful Activities Prevention Act, the use of which, and I do not think we should any longer talk about misuse or abuse of the law. This is the use of the law. The law is the instrument through which repression will be carried out and is being carried out of everyone, from the political opponent to human rights defenders. Chapter 4, which is from section 15 to 21, has been lifted, cut, paste, and has been parked in section 113, if I'm not mistaken. I'm not up to the mark, and it's very mind-boggling. After 30 years to start learning new numbers, like there's no 420, it's almost culturally tragic. UAPA defines terrorist act. It is the terrorist act where you have to meet the very high threshold of impossible bail under section 43D5, which even the Supreme Court has now been saying, how do you say there is no prima facie case made out, etc. That has been cut, paste, put in the Bharatiya Nyaya Sanhita under section 113. Under UAPA, there are at least some formal safeguards, like sanction for prosecution, a review committee to see if the case can be instituted. The Bharatiya Nyaya Sanhita is the routine law, is the ordinary law, not an extraordinary law. So what is happening now is the routinization of extraordinarily stringent and draconian provisions which are found in UAPA and in MACOCA are being routinized by bringing them into the Bharatiya Nyaya Sanhita verbatim, without even the formality of those safeguards, and thereby not only creating, this is going to create legal anarchy, and that is why it is no surprise that the police officers are delighted. Who gets to decide who will go under UAPA and who will go under section 113 of the BNS, because the offense is identical. Offenses are identical. In UAPA, they are from 15 to 21. In BNS, they've all been clubbed together in 113. This level of arbitrariness, and therefore when we are told that people can be recognized by their clothes, We don't know what will be the determinants of who will be arrested under what, apart from the very, very dangerous trend of routinizing extraordinary anti-terror provisions which are created the world over. Those laws are passed, to my mind, always wrongly, but they are passed in emergent circumstances to meet certain emergent threats, not the routine law and the ordinary law of the land. There are aspects that have emerged from our experience. One of them being police brutality, torture. There is enough documentation by the National Human Rights Commission and in Supreme Court judgments that torture is a reality in India. India does not have a specific codified offense of torture. We signed the UN Convention Against Torture in 1997. We have told the international community, not only to the people of India, but even the international community, since 2007 repeatedly, that we are going to ratify the convention by introducing a domestic law. The Law Commission of India in 2010 advised the government that you should pass a separate law. This was a great opportunity to do so. There is no offense of torture. Surely in Amritkal, we can at least have some respect for the body of the Indian citizen. Not only does that not get codified, there was a provision introduced in 2005 which said that if there is a custodial death or custodial rape, there is mandatory judicial magistrate inquiry. Many of you would recall the Ishrat Jahan case, which I represented the mother of Ishrat Jahan, who was killed in a fake encounter in Gujarat. The one time that we heard a glimmer of what may have transpired was a judicial magistrate's inquiry under the present section 176(1)(a) of the Code of Criminal Procedure, where he said that this was a fake encounter from his inquiry. They have dropped judicial magistrate, and the inquiry into a custodial death, custodial rape, or extrajudicial killing, which is deemed to be a custodial death, will now be conducted by any magistrate, which means at least in Delhi, we call them subdivisional magistrates, or maybe you call them executive magistrates. I don't know how Bombay's nomenclature, but these are civil servants who work under the government. The reason it was changed in 2005, and it is reinforced in the PUCL judgment of 2014, PUCL versus State of Maharashtra of the Supreme Court, which lays down the guidelines to be followed in a case of extrajudicial killing. So you actually have provisions of the law which are in defiance of established Supreme Court judgments, as handcuffing was mentioned. We have many judgments of the Supreme Court as well as guidelines of the NHRC on arrest, which says only in very, very extraordinary situations, taking permission of the court, you can handcuff. In Delhi, I was one of the counsels in the Parliament attack case, a very big criminal trial in the special court. None of the accused were ever handcuffed when they were brought for the hearing, and the hearings happened. Today, that discretion is not of the court. It is the arbitrary discretion of the arresting officer if he thinks you are a dangerous person, and that can be, how is that to be guided? The other aspect that was mentioned, and on this I was chatting with Vijay just before, I think there is some confusion being created, at least in my mind it's very clear. Personal integrity, bodily integrity, personal liberty stand very, very seriously jeopardized by the amendment to the period and when police remand can be taken. As some of you know, when a person is arrested, as per the present law, which has been the law of this country forever, and nothing so different happened that investigations could be completed that we needed to alter this. The police has a right to take take police remand within the first 15 days of arrest. Once the first 15 days of arrest are over, the investigation, of course, can continue, and the filing of charge sheet, if the person is in judicial custody, has to happen in 60 days or 90 days, depending on the nature of the offense. Now, what is being said is the police can still take only 15 days police remand, but at any time over a period of 40 days or 60 days, again depending on the nature of offense. So it's not the first 15 days. So what is the implication? How does it matter? What is police remand in our country? Really, does some breakthrough in investigation take place? We do enjoy Article 20's right to silence, which still stands in the Constitution. So it's not as though some eureka moments of investigation happened in police custodial interrogations. But the fear of torture, the fear of being implicated otherwise, and what we have recently seen in actual cases, both against journalists, human rights defenders, and political opponents, you can be turned into an approver. You can be turned into giving statements against the other accused. That is why that extended period, because after all, it takes time to coerce somebody to tell a lie and to intimidate people, to threaten them in multiple ways and their families, etc., etc. And therefore, that period of police remand total will remain 15 days, but staggered over 40 days or 60 days. The total period will not change. Secondly, now let's imagine a scenario where somebody has to apply for bail. In that 40-day period, actually, there will be no bail possible. The minute you will say, and I'm sorry if it's a little technical, but we are in a state of affairs in the country that we'll all have to learn more than we need to. If you will file a bail within the 40 days period, all they have to come and say in a court is, oh, we still need to take remand. We need to have some more custodial interrogation. Until the prosecution, and these applications are made very casually, because nobody asks them about what are the grounds for remand, but you've already taken remand, what is the new thing you want to ask? So then take remand just now, why are you waiting for the 39th day? Courts are usually a little reticent to ask these questions. And all that will happen is that till those 40 days or 60 days, actually, you are saying the person cannot get bail, because that will be the effect and impact of it. One of the things that the Indian Penal Code has, and that really is Victorian morality at its worst, is the criminalization of voluntary termination of pregnancy. Abortion is a crime even if a woman wants to commit it, because at that time, that is how it was understood under British colonial rule. There are umpteen judgments of the Supreme Court, from Puttaswamy to recently Miss X versus Principal Secretary Health, saying women have absolute autonomy to take decisions on reproductive rights. The Medical Termination of Pregnancy Act actually was introduced to carve out an exception for the doctors and the medical practitioners to be able to conduct the termination of pregnancy. Otherwise, they would have committed a crime. Verbatim, the provisions of law on criminalization of abortion have found place in the Bharatiya Nyaya Sanhita. So I'm not sure what is, and jurisprudence has marched forward. And yet we are not seeing any space for acknowledging women's autonomy over their own lives and bodies. Similarly, Section 377, finally read down in Nafte Johar by the Supreme Court, was retained only to the extent of non-consensual sexual assault on adult men. We have POCSO for boys and girls. An adult male upon whom sexual violence is committed, or even a trans man, and we know that sexual violence on trans community, their bodies are targeted, particularly in custodial situations and police, etc. There is documentation to that effect. Recently in Karnataka, Prajwal Ravana's brother has been arrested under 377 because Suraj Ravana. Let's imagine a crime of that nature committed on 1st of July. There is no provision of law. You have created a gap in the law, and that is what happens when you do not consult. Groups that are vulnerable to this kind of violence, and there is no conversation with them or in Parliament, that there will be challenges in the court, in the constitutional courts, the High Court and the Supreme Court, to these laws. But we are also looking at chaos and the kind of legal mayhem. And who will bear the brunt of that legal mayhem? Who will, if the court is saying this is the law, how will we argue? Who will decide under which provision of law? At least I presently don't know. We are all, there are annotated criminal manuals, and all we are doing is going cross-eyed trying to see what happened. And that's when I said, if today we were to say 302, everybody knows it's murder, 420 is cheating, it's not from 1st of July. So what is the reason to create this level of mayhem? Is it not disempowering for people? How does every ordinary person today get to suddenly overnight, I am not, I can't claim that I know the new sections, get to know what is the law, what are the changes, what are the powers that the police have got. So it's also about what is this machinery of the government trying to do in our midst. And as I said, there will be challenges. Challenges to such matters, as we know, take very long. Teesta, myself, we have all challenged the anti-conversion, so-called freedom of religion, but actually anti-conversion laws, which are having a direct impact, particularly on the lives of the young every day who are being arrested. The challenge is pending for long since in the Supreme Court. It's not been heard. Sedition is in abeyance. But from 1st of July, what is the new monstrosity in our midst? Therefore, these conversations are very important because, according to me, it's not just about the constitutional challenge. I think the real challenge has to come from our midst. These laws are for us, and we will decide what the laws will be. Thank you.
Thank you, Advocate Vrinda Grover, for demystifying the not so good new criminal laws. In the not so good new criminal laws. Yes. We also welcome in our midst Sister Vinita. We call her a sister activist. Thank you for being here today. Father Cosmas Ekta from St. Teresa's Church, Sister Margaret from St. Michael's. We have also our Sabha team, Deanery Councillors Mohan and Edward, and our executive members, Marian, Alex, and Tracy. Advocate Vijay Hiremath. Vijay Hiremath is a Bombay-based lawyer who has also worked with India Center for Human Rights Law. He is one of the few lawyers in India who are willing to take up cases that concerns human rights, from seeking inclusion of the transgender community in public sector, protection and rehabilitation of child laborers, to representing those wrongly incarcerated by the state and facing the wrath of the state when representing the kins of the victims of fake encounters. We have the pleasure of listening to Advocate Vijay Hiremath. Can we give him a big hand?
Good evening, everyone. Thank you, Dolphy, Teesta, all the organizers. It's actually a very tough task to speak after your senior or your eminent senior has spoken. Generally, the courts don't listen to the juniors also, but I'll try my best to touch some of the things which Vrinda has left to me to touch. First of all, every time this government does anything, it puts us in more confusion why they have done it. What is the reason they have done it? Is there something sinister? Because they can't do anything straight. They have no goodwill to do anything. Whether it's the farm laws, there are any other laws they have taken, there is something sinister. But in criminal laws, because as Vrinda said, they had this consultation when people were dying. Because it was in the middle of COVID. There were bodies flowing, and we in the evenings on every Sunday were sitting and discussing, because that was also important, because what they are going to do with the live people who are not going to die because of COVID. So we decided to participate and deliberate, and middle of that, many of the lawyers' families would fall ill. They would join back after many weeks, and this was the process that they had, which shows that there was no seriousness in the process. If you expect people to put their minds in middle of a pandemic, there is no seriousness to this process, and we don't know. So when you go through these laws minutely, then you realize what the plan is, what the sinister ideas behind they have to bring in these laws. At one level, you see that they have done a copy-paste job. Decolonization, there is no decolonization. Because if there was decolonization, the laws should have been more humane. You are an Indian government now, you say that the British has left with these laws, we will make laws. So what kind of laws you will make? You should have made more humane laws. Reduce the punishments. Death penalty should have gone. Marital rape should have been introduced. These are the things they should have. None of these things are there. And what they do, I will point out few of the provisions, how they are harming, going after the people, but there is a confusion. Neither they want to go after the complainant's rights, nor they want to go after nor they want to help the accused rights, but there is a plan to bolster the state, take more powers from the people, and that is the sinister plan they have. These laws, if you go to see, seem to be more draconian than what the British brought the laws. And one will realize at some point of time, probably they were better. You come back and make laws, somebody will say to them. And these laws are not accepted to us, though it is done by an Indian parliament. Now I'll give you some of the examples. Vernon is here, and he knows the discharge applications in his case are pending for last 6 years. 6 years have passed, no discharge application has been decided. Out of 18 people, one person's discharge application has been decided. And now the courts, the new law says the discharge should be decided, filed, not decided. Decided, there is no time limit. But the moment the accused gets a copy of the charge sheet, the accused has to file a discharge application within 60 days. What is the logic? Nobody knows. Apart from curtailing the rights of the accused, many accused are illiterate. They don't have lawyers till the trial starts. They don't understand what is there in the charge sheet, what is not there in the charge sheet. Now they also have a same time provision to produce them through video conferencing. So these accused may not be able to meet their lawyers and know who are their lawyers, who the family has arranged as a lawyer, and they expect the discharge applications to be filed within 60 days. First 60 days they can take police remand anytime. Time limit for filing the charge sheet is 90 days. But the discharge application, moment they get the papers, has to be filed within 60 days. If anybody has seen the Bhima Koregaon charge sheet, it is more than 10,000 pages. I have not read all the 10,000 pages. I'm I'm representing one of the accused, so it's impossible to, when you give these timelines. And let me give an example. When we started working with India Center for more than now 2 decades ago, my work was going to jail and taking up cases of people who can't afford lawyers. The 2 cases I will tell you why discharge without a timeline is important. There was this case of Johnny John, or who was called David. He came from Kolkata and was living on the footpaths near Matunga, Sion. One fine day he gets arrested, and because they also have misused DK Baisu guidelines, They said there were 18 cases between Sion and Matunga police station pending of car tape theft. That time there used to be car tape theft. So, as per the DK Basu guidelines, the control room is informed one guy is arrested for car tape theft. So, both the police stations together put 18 cases on him. He's arrested. After the 17th case, he has slashed his wrist because he's tired of police custody. He's tired of the constant torture in police custody. And finally, the magistrate grants him judicial custody. He is sent to jail. We as lawyers, young lawyers, went to jail and met him after 11 months after the charge sheet filed. First he said, well, we asked, where are your papers? साहब मेरे को बहुत गुस्सा आया तो मैंने सारा पेपर जला दिया. That was his response. Okay, we get the papers. After it took about 3 months to get all the papers. In all the charge sheets, there was the same car tape which was put in 18 cases. He was discharged in 18 cases. And this was after a period of 1.5 years. And today they are saying you file the discharge application in 60 days.
Yeah.
The second case, I still remember, is of one woman close by from Dharavi, Fatima. She had gone to Dubai, earned for some work there, earned money to basically to have a good wedding for her daughter. She comes back, police want the money, some money from her. She refuses to give. One fine day, she is arrested in a murder case. And she doesn't know. For 2 years, she was 2 years in custody. We meet her in jail after 2 years. We see the charge sheet, there is absolutely no evidence. We point out to the Sessions Court, there is no evidence. After 2 years, she is discharged from the case. And today they are saying file it within 60 days after you get papers. And there is no explanation. As I said, there is no logic to what they do. It's completely ridiculous. And let me tell you a fun fact also. The Home Minister filed his discharge application after 6 years. Rest is history. A judge changed, a judge died, and the Home Minister got discharged. I'm not saying anything more. I'm just saying, giving you the facts. So, and these laws have come from the Home Ministry, which should have come from the Law and Judiciary Ministry. This has been tabled by the Home Minister. This is his baby. At least he should have seen that provision that I could not file a discharge application in 60 days. I took 6 years. But no. As I said, there is no logic to what they do. Then, there is a new provision. It's understood if the accused doesn't come before the court, you cannot proceed in a trial. But there is a new provision. Trial can happen against a proclaimed offender. If an accused is not found, the court will declare you a proclaimed offender. There are procedures after that what you do. You publish notice, you go attachment for the property, all this is there. But now, and never there was a procedure to continue the trial against him because it's unheard of in any country in the world that in absentee of the accused, you are going to try him and convict him. And they say that all the evidence will be considered. How? We don't know. Who is the lawyer going to take instructions from? If the accused is there, not there, we don't know. And it is very easy to convict somebody like this. The police has to just come and give a report saying that this accused was not found. And the police will, and the court will say proclaimed offender, and they will continue with the trial. Suppose he is somebody from Konkan. He has gone to Konkan, he has locked the house here and been in village. Police is not going to bother to find him, go and find him in Konkan. They say, मैं घर जाके आया, बंद था घर. Proclaimed offender, trial will proceed and he will be convicted. Something which is unheard of, extremely dangerous. Activists shouldn't leave their houses. I feel. Because otherwise you will be all proclaimed offenders. There is something new to it. And again, as Vrinda said, there are many things they have done which go against what already the Supreme Court has laid down the law, and there are many judgments to that. There is a provision. Again, when they come with these numbers, nobody has any idea, nobody has any logic. We also trying to understand why would they have done this. any complaint, cognizable complaint, which is punishable between 3 to 7 years. If you have a complaint, and these are many offenses, right from stabbing, slapping, sexual assault, there are several offenses under POCSO also, which is a Sexual Offences Act against the children. So you go to a police station now from 1st of July. Today you can still go. But if you go after 1st of July, they say the police officer, that is the SHO, station house officer, can decide prima facie whether there is a case or not, and then he can decide whether to file an FIR or not to file an FIR. This is extremely dangerous. First of all, now they are putting the police in the domain of judiciary. Whether a prima facie case is there or not was completely with the judiciary to decide. Police can't decide the prima facie case. The courts had continuously said police has to register the FIR moment there is a cognizable offense, and they cannot do anything more than that. Even then they wouldn't file an FIR, we would go to court regularly. But now you are giving them a free hand. This is open to corruption. This is open to many other things that can happen. And we know how the police function in this country. FIRs of marginalized people will never be taken if there are petty offenses. You are basically saying, you get murdered and come to police station, I will take your FIR. If you are slapped, you are stabbed, I am not going to take your FIR because it is meri marzi hai bhai. Main lunga, nahi lunga. It is all now what that movie was. Singham. So every SHO is now given a right by law to be Singham. Whatever he can do is the law. There is another interesting provision, and even Dolphy should be worried about it. This thing. They say that any place can be declared as a jail at any time on the recommendation of the central government or the state government. So suddenly state government says we are all in jail here, we can be kept here. But this provision will be very useful for all the resorts after the Maharashtra election. The MLAs will be kept there, and then they will say, till you sign with whoever you support, till that time this is a jail, because the Maharashtra government has declared it is a jail. There is no logic again. Why would you say that any place? What is the meaning of any place? Please think of Kashmir, what they did. And this is what they are trying to do to the entire country. They declared theatres, movie theatres as jail. They declared stadiums as jails, and they put people there. This is what they are going to do. And they are putting these provisions very silently in these things. When they say we have done a copy-paste job and there is nothing else, these are the things they have introduced. From draconian laws, they have brought into the normal laws, which is extremely dangerous. One of the other provision which is still debatable, I would say, little bit, I don't know, there is no logic still, but debatable. This thing, accused can be heard at the time of complaints. That is a private complaint, not FIR. So what my thinking is that the accused will be called and heard, and the judge may dismiss the complaint saying that I believe in the accused or I don't believe in the accused, and continue with the complaint. But this is going to repeat the process, because the accused is, even if the process is issued against the accused and he is summoned as an accused, he is not going to stop there. He will go to the higher courts, as that is his right. There is nothing wrong with it. So I don't know why, when they say that we want to speed these things in courts, when they are creating these hurdles, there is repetitions which will happen in several courts, when the infrastructure of the judiciary is very, very abysmal in this country. People should just to have an experience, go to Bandra Magistrate Court and see how the court functions, and Kurla Magistrate Court, how the court functions. I'm not batting for AC courts, I'm not batting for luxurious courts as Ahmedabad has seen it. But I'm just saying, give the basic infrastructure. One public prosecutor is divided between 4 magistrate courts in Bombay. One steno is divided between 4 magistrate courts. No orders are passed. and then you are creating this kind of system where it is just going to create a whole lot of mess. There is another very interesting provision where basically any complaint against a police officer, which they say whatever he does in the course of his duty is going to be as good as impossible. Even today, to prosecute a police officer is a Herculean task because you need sanction. And only if a sanction comes, then you prosecute. There are hundreds of judgments used which say that it is very difficult to get witnesses against police officers. But there have been convictions. Some of the convictions the Vrinda has got. It's, as I said, it's a Herculean task. But now, if the FIR is not registered, what do? You go to the SHO. And that SHO will say, ये 7 साल के अंदर है तो मैं नहीं लेता है. But if it is more than 7 years, we'll say इसको मारा है, मर गया है, murder लगाओ. I keep going back to 302, forgetting it won't be 302. I'm sorry. I have to learn the new section still. So, the complaint may be taken. So, he will have to go to the magistrate to file a private complaint, which in today's case was a very normal thing. If the police doesn't take an FIR, you go to a magistrate and file a complaint against the police officer. Magistrate will say, bring all the witnesses, I will issue process. And then the rest of the thing of sanction may continue. At some point of time, he may say that sanction was not required because this was not part of the duty. But today, the two big hurdles which they have created for a complaint against a police officer is that once a complaint is filed before the magistrate, the person against whom the complaint has made, he is to be issued a notice and he has to come with a report saying that whether it was in course of his duty. I have committed a crime and I have to go and admit that I have committed a crime. If he agrees that it was not in course of duty, then the SHO or the superior officer of his has to come and give an affidavit saying that this all happened and it was not in the course of duty, hence prosecute him. Please tell me which police officer will be prosecuted in this country by private complaint.
Yes.
Nobody. And this is another sinister thing they have added. Please keep always Kashmir in mind when I am discussing this. This has all happened there. Now another thing, they say that they are making it for Indians, but they are taking away all the rights. As simple as mercy petition after death to be done in 30 days. I have no understanding why this is done. There is no logic. It is as good as ridiculous. Many times the order of the Supreme Court doesn't reach the jail for 6 months. I'm not joking. It is 6 months the accused doesn't get the order. Then they say mercy petition can be filed only by the relative. It's because Vrinda filed too many mercy petitions. So if I don't have a relative and I don't file a mercy petition, I will be hanged after 30 days. And you know, if somebody looks at the mercy petition jurisprudence in this country, they have been filed after a long time. They take a long time because you need to get so many details of the person. Go to his villages, find out how was his upbringing, what happened. There are so many factors that go into a mercy petition. And secondly, anybody should be allowed to file a mercy petition. You are feeling wrong that somebody is being killed in your country, you should be allowed. Why should that right be taken away? And I'll also tell you why relatives may not be interested. He might have property.
Yeah.
And relatives say, मरने दो, उसने offense किया है. And many of the death penalty cases are out of property, are out of crimes against women where the family do not want that person to be with them. And then you have created these hurdles. There is no logic to this, why only a family member can file a mercy petition. This has happened in some of the states. We have opposed it. I don't know how Justice Chandrachud says, I'm welcome to this. I don't know whether he has read it. Because there are contrary judgments of his from Bombay High Court. But trial by video conferencing is something which he opposed as a judge, and he said by video conferencing only remand can be done. I have an order. I am not talking. Justice Dalvir Bhandari's and Justice Chandrachud's order, which was written by Justice Chandrachud, and now there is trial by video conferencing, which Justice Chandrachud says that this is all welcome. I'll tell you the trick of video conferencing. You can hear nothing in the court. Please come to Sessions Court in Bombay. You don't get even the range. When he talks about digital courts, I want to tell him that please get us internet in Sessions Court first. And then we'll talk about digital courts. And what if suddenly while cross-examining, accused has to give instruction to the lawyer, and that the entire court, all the judge, whoever the judge is, whoever the prosecutor is, will hear the instructions. So it is completely goes against the grain of criminal law, goes against the rights of the accused, and hence trial by video conferencing is something which should be opposed in total. It is state has taken your custody. It is the duty of the state to produce you before the court. It's as simple as that. You cannot give excuses. Today आज बंदोबस्त है, आज गाड़ी नहीं आ रहा है, आज मेरे पास पेट्रोल का प्राइम मिनिस्टर ने रेट बढ़ाया है, इसलिए हम गाड़ी नहीं चला सकते. You can't give these excuses. I'm sorry, you have taken away my right. You're putting me in Taloja jail. You please take me to the court and do the trial. Very dangerous something is something, commutation of sentence was completely within the domain of the state government, because law and order at the end of the day is a state government subject, and state government can decide whoever sentence they want to commute. Of course there are guidelines. It is not that they do it randomly to anybody. And so the earlier, in the present CrPC, it said in some of the cases in consultation with the central government. Now the word consultation has been taken out, and they say in concurrence with the central government. This is also with a dream that they will never leave that central government. They think that they will always be there. Because otherwise they wouldn't do such a thing. But it's also dangerous to federalism. Why is something which is a state subject, they will every time go begging to the central government to give us the permission to commute the sentence or not commute the sentence? And what if the state government doesn't want to commute the sentence and central government wants to commute the sentence? There are a lot of examples. That is a rape case from Rajasthan. Central government will say commute the sentence. But now they have both the governments the same. Double engine hai wahan pe abhi. And people who are doing intermittent fasting, please be careful. While you are intermittent fasting, don't say you're protesting about something, because you can be arrested. You just say, I'm doing intermittent fasting. Don't attach it to any kind of your philosophy or politics. Because as Vrinda said, hunger protests have been criminalized. Today, it was intention to how do you criminalize Gandhiji. So this is what they have done. And I will conclude finally, we can take questions. But the final and the very funny thing they have brought in is community service. Again, there is no definition of community service. We have seen in recent past what happens with community service. You take a posh, go and kill somebody, and then you, as a community service, you have been asked to write an essay. So this will be the community service, which has happened already, and you introduce it. Sardarpura accused also. There have been many instances. In rape, accused has been asked to tie a rakhi around that woman. This is community service. So this is extremely dangerous laws or changes we are looking at. I'm only reminded of two things. That the German poet, which we all know, that they first came for the communists, we didn't speak and all that. But now, finally, they are coming for us. They have come for the chief ministers. Nobody has said anything. They are finally coming for everyone now. Please be careful about this. know this. And when 370 was repealed, lot of our friends said from Kashmir and outside, the intention is not to bring Kashmir into India. The intention was always to make entire India Kashmir. And these laws are the process to start making India a Kashmir. Thank you very much.
Dated June 28, 2024, to the Prime Minister Shri Narendra Modi, New Delhi, Leader of the Opposition Shri Rahul Gandhi, New Delhi, President of the Supreme Court Bar Association Shri Kapil Sibal, New Delhi. Subject: appeal from citizens and civil society organizations to stay the implementation of the new criminal laws and ensure elaborate parliamentary debate on the proposed changes, as also detailed consultations with stakeholders and experts. Dear sirs, greetings. On July 1st, three criminal laws, namely Bharatiya Nagrik Suraksha Sanhita 2023, Bharatiya Nyaya Sanhita 2023, and Bharatiya Sakshya Adhiniyam 2023 are slated to come into force. We would wish to point out that these three laws were hurriedly pushed through Parliament on 28th December 2023 without adequate when 146 members of Parliament brackets MPs were suspended from the House. Our major concern is that the amendments made in the then existing laws are such that they are mostly draconian in nature. Moreover, they have been passed without any deliberations, something that is anathema to the functioning constitutional democracy. They deal exclusively with matters of life and liberty and criminal harm that can be caused to an individual in other multiple and various ways. They also adversely deal with civil liberties of citizens, more particularly in the matters of freedom of speech, right to assembly, right to associate, right to demonstrate, and the other civil rights which can be criminalized as part of the law and order provisions of the three laws. The new laws, in fact, violate the principles of liberty, equality, and non-discrimination enshrined in the Constitution of India. Essentially, these new criminal laws would equip the government with adequate power to follow out our democracy and transform India into a fascist state, should the government choose to deploy the new laws to their fullest extent. The proposed new laws would enable the government to dramatically scale up arrest, detention, prosecution, and imprisonment of law-abiding democratic opponents, dissidents, and activists. Some of the chilling factors of the new criminal law that require special attention. One, the criminalization of legitimate, lawful, non-violent democratic speech or action as terrorism. Point number two, the broadening of the offenses of sedition in a new and more vicious avatar, what could be called sedition plus. Point number three, the expansion of the potential for selective prosecution, targeted, politically biased prosecution of ideological and political opponents. Point number four, the criminalization of a common mode of political protest against government through fasting. Point number five, encourage the use of force against any assembly of persons. Point number six, exponentially enhance police Raj by criminalizing, resisting, refusing, ignoring, or disregarding to conform to any directions given by a police officer. Point number seven, enhancing handcuffing. Point number eight, maximizing police custody during investigation. Point number nine, making the recording of a FIR discretionary for the police. Point number 10, compelling all persons, even those not accused of any crime, to provide their biometrics to the government. And point number 11, shielding of some of the Sangh Parivar activities. It is this impending threat to the democratic structure of this nation that has compelled us to seek your immediate intervention to stay the implementation of these questionable laws, and until their implications are thoroughly re-examined by a team of legal experts and debated on the floor of the Indian Parliament. As we are sure your esteemed selves are aware, the West Bengal and Madras Bar Associations have already expressed great concern at the manner in which these laws have been passed and their content. We urge that every step is taken to ensure that until re-examination and debate. All three laws are stayed from implementation on July 1st, 2024. Signature campaign launched in Mumbai on June 28, 24. Now, if you're in agreement to this, you're going to pass this around. Can we have a voice vote here?